So I'll just briefly introduce myself. My name is Jonathan DiCarlo. I'm a PhD candidate at the University of Toronto in the history department, and I'm also affiliated with the Mark S. Bonham Center for Sexual Diversity Studies. Broadly, my research, I'm a legal historian, so my research involves the legal history of police violence against the queer community, specifically with respect to police entrapment practices and invasions of queer spaces like gay bars and gay bathhouses, which led to prosecutions. And my focus is on New York, Chicago, and Montreal and Toronto in Canada. So both Canada and the US. In terms of the Chiles v. Salazar decision, which I personally like to call the Karen v. Salazar decision, I'm going to just kind of go over some of the more kind of legal concepts that were discussed in oral arguments and kind of like contextualize them within the case. So I know that a lot of people were a little bit puzzled by what strict scrutiny meant because there was a line of questioning that was initially brought up by Justice Sonia Sotomayor, who was a liberal justice on the court appointed by Barack Obama. And there was this kind of discussion about, quote unquote, remanding the case so that it is reviewed under strict scrutiny. So, strict scrutiny is one of three standards of review to determine whether a law or government action violates the United States Constitution. There are three standards of reviews for this kind of violation. And so the lowest one of that is called rational basis review. The second lowest or intermediate level would be intermediate scrutiny, and then the most stringent one is strict scrutiny. And basically, each of these levels invokes a certain set of rights or freedoms, and it puts a higher burden on the government to prove certain things in order for the law to remain in place. So even under the United States Constitution, rights are not universal. They are subject to kind of rational, reasonable limits that the government can put in place in order to protect the broader public. And so when we're talking about rational basis review, which is the lowest standard, generally we're talking about like economic regulations and social welfare laws that don't involve a specific group or class of American, like occupation, race, sex, sexual orientation, anything like that. And generally, in order for so if there is a law that violates the US Constitution or restricts a right, under rational basis review, the government would just have to prove that the law is rationally related to a legitimate government interest in order for the law to remain in place. One of the things that I will discuss later is some of the precedents that the Supreme Court invoked in oral arguments. One of the key ones is the Skrmetti case, which was a case decided last term. A lot of people probably remember it because it is the case that decided that a Tennessee ban on gender affirming care for minors was constitutional. In that case, the Supreme Court said that transgender status isn't sex or gender for the purposes of the 14th Amendment or Title 17 of the US Code, and therefore it is not subject to like a stricter, either in this intermediate scrutiny or strict scrutiny, it's only standard subjected to rational basis review, which again only requires that a law is rationally related to a legitimate government interest. In the case of Skrmetti, quote unquote, protecting minors from abusive medical practices. The second one is intermediate scrutiny, and generally this is for like gender-based classification, so sex discrimination, laws that discriminate against children, specifically children that are born out of wedlock, some speech regulations, but not all. And in these cases, the government bears a burden of proof to show that like a classification or restriction is justified and that it's a very, very tight as possible so that it's restricting as least as possible, but it has to be restricting less than it would be for a rational basis review. And then thirdly, which is the one that was mentioned a lot in the oral arguments for this case, strict scrutiny, which is typically used for a lot. So fundamental rights like voting rights, marriage, travel, privacy, First Amendment. and it really generally is invoked when it involves special classifications like race, origin, religion, alienage, stuff like that. And under this heightened level of scrutiny called strict scrutiny, a law is upheld if it violates a constitutional right only if it is narrowly tailored to achieve a compelling government interest. And so there's a couple of things here that are relevant to this case, which firstly, the government bears the burden of proving that a law is narrowly tailored, and the government bears the burden to prove that the law is there to achieve a compelling government interest. So the government has to prove that it's a compelling government interest. And that is particularly important in this conversion therapy ban case because there was a lot of discussion in oral arguments about how especially according to the petitioner, so the lawyers representing Chiles, there was like a lot of discussion or a lot of them arguing that the state of Colorado never presented any kind of specific proof that conversion therapy is harmful, or that I should clarify that talk-based therapy, conversion therapy, is harmful. And so the reason that there was a lot of discussion about this being reconsidered under strict scrutiny is that there's an argument that the government of Colorado would never have been able to prove that the law is narrowly tailored or that it is trying to achieve a compelling government interest because according to the lawyers for the petitioner, the state of Colorado couldn't offer any evidence in the forms of medical studies that show that talk-based conversion therapy is harmful. The second criteria is that it must be the least restrictive as possible to meet its goal. So sometimes you'll find cases that are reviewed under strict scrutiny. Generally, the review under strict scrutiny is done at the district court level. So under federal law, you have 3 levels of courts. You have the district court, then you have the Circuit Court of Appeals. So when you hear in the news like the Ninth Circuit, the 10th Circuit, the Third Circuit, the Fifth Circuit, that's the Circuit Court of Appeals, and that's the second, that's the intermediate courts. And then the final review goes to the Supreme Court under federal law. Under state law, it's a bit different. There's a few echelons of that, and then the Supreme Court could then intercede in certain cases after the state Supreme Court. It's not always called the state Supreme Court, but the state's highest court intervenes. The Supreme Court has jurisdiction to intervene after that. The last criteria of strict scrutiny is that a law is always presumed to be unconstitutional unless the state proves otherwise. So in the case of the Chiles v. Salazar case, there was an argument on the side of the petitioner for Chiles and also the federal government who presented as amici. I will explain that in a minute. Both argued that this case should be reconsidered under strict scrutiny because it triggers the fundamental right of freedom of speech under the First Amendment. Does anybody have any questions about that before I move forward? Because I'm going to build on these concepts. I want to make sure that it's clear from the beginning.
I have a question, but I'm not so sure if that's something now or later. When I was listening, something that really confused me was that concept of talk therapy not being harmful. And then they would mention aversion therapy. And that confused me because my understanding of the majority of the research is that they talk about reparative therapy, which is a form of talk therapy, being deeply harmful. So I got really confused how they could make the claim talk therapy is not proven to be harmful when that's what the research shows. So were they focusing only on behavioral changes like electroshock therapy and vomit therapy? Is that what their claim was? Because that seems, to me, that seems ridiculous, but it seems like that's the legal argument they were making.
Yeah, I can answer this now. I'll just contextualize this a bit. I know that people are generally brought up to think of courts as impartial, independent, and as a scholar of the law and legal history, I will just kind of like invite you to not think about the courts that way. The courts are political actors. Everyone in that courtroom was a political actor, whether they want to admit it or not. And so you have to listen to the court arguments, the oral arguments, from a position that the Republican appointed justices, generally speaking, when they are speaking with a petitioner who is trying to accomplish something that is like conservative bucket list like this, they are working together. They are going to pose questions that are going to be like softball questions that are meant to get the petitioner's lawyer to elaborate. And so what I noticed adopting this kind of critical lens in oral arguments is that when the petitioner for Chiles was speaking, other than in their initial opening remarks, which are very short, they never actually mentioned sexual orientation. They leaned extensively on gender, like on gender identity conversion therapy. And my analysis is that this occurred because of the political salience of transgender status in current politics, which has a lot more traction than, say, sexual orientation. If and I've kind of some I've had an offline conversation about this, and I'll mention it here, is that the case is a bit more complex than if it was just conversion therapy for sexual orientation, which I think would have been not received as well. But you have to always keep in mind that the way the United States' political system is built, the Congress is essentially ineffective because of the filibuster and because of the kind of partisanship. And so the way the Supreme Court operates through its concept of judicial review, which allows them to throw out laws on the basis of constitutionality, has made them essentially a de facto policymaker. You know, we have gay marriage because the Supreme Court is a de facto policymaker, in the same way that we don't have abortion because the Supreme Court has become a de facto policymaker. And so when cases are brought, when a petition is filed for a case to be heard by the Supreme Court, the way it works is you need 4 justices to agree to take it. There are 6 conservative justices on the court, and generally speaking, justices will want to take up cases where they think that they have a good enough case and argument to achieve some policy objective that fits their ideology. And so the fact that transgender is mixed into this definitely adds a lot of political saliency for the right. In terms of this discussion about talk therapy versus aversion therapy versus reparative therapy. So a couple of things. So you might have heard mentioned this concept of speech adjacent to conduct doctrine. It was mentioned quite early on, let's say in the first 20 minutes of oral arguments. And basically what that means, so you have in US law, you have free speech, right? So you can burn a flag, generally speaking, you can say things about the government without fear of government retribution, in theory at least. So that's free speech. Now, when someone is acting in a professional capacity, there have been instances where that has been recognized as free speech. However, there is a second set of legal precedents called that make up this. It's not an official doctrine. It's like a more of an informal doctrine that's been dubbed the speech adjacent to conduct doctrine. And that is particularly relevant here. For example, if you were to go to a hospital and say you are having thoughts of suicide because you don't want to be gay, and the doctor tells you that you don't have to be gay if you don't want, and then they offer you medication for anxiety or for depression or whatever, that is not necessarily protected speech because there is a conduct attached to that, prescribing of medication. So there was this whole discussion in the oral arguments about this kind of concept, and the people that were, you know, there arguing for Chiles were trying to make a distinction between talk therapy and any other form of CT, because in their telling of their narrative, talk-based therapy, in their view, should be considered free speech because it's only talking and it's not doing anything else. There's no conduct attached to it. So the scrutiny or the kind of laws that would be legitimately put in place to curtail like doctors, psychiatrists, anybody that's performing a medical conduct in addition to talking, those kind of regulations, if the Supreme Court would overturn that, that would create a whole bunch of chaos because there's all these laws like protecting people from harmful conduct of doctors. But they were trying to carve out a distinction between therapy, the conversion therapy that occurs in a counseling session by someone who is professionally accredited or licensed by the state. And so that is kind of where this case turns. I will, at this point, kind of bring in the precedents that I talked about earlier. So there's two that I think, so in the oral arguments, there were two specific precedents that kept coming up. One is this case called NIFLA, and one is Skrmetti. NIFLA is basically a case where the government of California, I believe, mandated abortion providers to like post disclaimer information on clinic websites and whatnot. And the Supreme Court ruled that that was compelled speech and not constitutional. And then Skrmetti. And Skrmetti is a case from Tennessee about a Tennessee ban on transgender, or not transgender, gender affirming care for minors in the state. And in that case, the Supreme Court ruled that transgender status, or someone whose gender identity falls under a transgender or not cisgender, that those individuals are not classified, that any laws targeting those individuals are not targeting them on the basis of their sex. If it doesn't make sense to you, that's because it doesn't make sense, because this court is really like great at like gymnastics, mental gymnastics. So like, yes, I acknowledge it doesn't make sense, but that's kind of the ruling. So they ruled that it doesn't target someone on the basis of their sex. As I mentioned before, strict scrutiny as a level of, as a kind of tier of review. Sex classifications is one of the classifications that triggers strict scrutiny. So since they said that transgender status doesn't fall under that, therefore, a law that bans gender affirming care should only be reviewed under rational basis review. And I'll just repeat the standard to kind of give you an idea of the distinction. Rational basis review is just requires that a law be rationally related to a legitimate government interest. So obviously protecting minors, and I say that with massive air quotes, is a legitimate government interest for the state of Tennessee. And so as long as it's rationally related to protecting minors, a law like a ban on transgender or gender affirming care is legal. The other case I want to talk about before I open the floor to questions at large is 303 Creative. People might be familiar with this case. It was 2 terms ago, I believe, also from Colorado. And in this case, it was about this woman who wanted to create like websites for people's marriages. And so she filed, so basically Colorado passed a law. Again, we're talking about laws in Colorado. So Colorado passed a statute adding to their Anti-Discrimination Act, so CADA, and saying that you couldn't discriminate if you are a provider, like any kind of like service provider. You couldn't discriminate on the basis of someone's sexual orientation. And so this woman, Lori Smith, who created 303 Creative as a like graphic web designer, filed a case saying that this part of the Colorado Anti-Discrimination Act violated her First Amendment right for free speech because it restricted her expressive work. So her like art of creating a website, they argued that it was like her expressive work and that therefore it's speech. So in that case, the Supreme Court ruled that expressive artwork is speech and therefore couldn't be restricted by the government. So it's a very similar case. So they had, because it triggers First Amendment rights, it had to be reviewed under strict scrutiny, and that it didn't meet the guidelines. So that part of the statute was exempted from that because it was considered compelled speech in favor of queer people, because she couldn't create a website and reject clients that were not heterosexual. And so I bring that case in just to kind of set the kind of foundation for what to expect in the Chiles v. Salazar case. So just in the last 2 minutes before I kind of turn it over to questions, I will just say that I've seen a lot of chatter online. I've had a lot of people reach out to me. I'm not especially optimistic about this case for a few reasons. Number one, I don't particularly think that the Colorado Solicitor General did a great job in her oral arguments. She got tripped up a lot by incessant questions by Samuel Alito. It seemed that everyone and their mother, including the liberal justices, seemed confused about the whole aspect of studies. And I don't know the psychological literature on conversion therapy. Like, that's not my domain, but it seemed to be that there were a lot of arguments indicating conflations between aversive therapy, reparative therapy, talk-based therapy, and done to adults versus non-adults. And so there at one point there was, so Justice Sonia Sotomayor threw a question out there, hypothetical. If you've ever listened to oral arguments, there's like a million hypotheticals that they throw out. So she threw out a hypothetical about someone who is anorexic and goes to see a doctor, and the doctor or a therapist, and the therapist, you know, says, well, maybe you should try just continue doing what you're doing or something to that extent, and trying to make the argument like, do we really need a study for something that's obvious? But that didn't really go very far. So I think that at large, just the fact that they took this case is a sign that they are trying to broaden, again, thinking of the justices as policymakers and not as independent jurists. I think that the fact that they took this case is a sign that they are trying to broaden what they already started in 303 Creative, which is like kind of expanding what is free speech and restricting limits that can be placed on free speech. There was this whole kind of like issue about what's called remand under strict scrutiny. Sotomayor first brought it up. I think it was subsequently brought up by Justice Amy Coney Barrett, who's a conservative on the court, possibly Justice Thomas, if I recall. Remand basically means that they would send them back to the lower courts and clarify something. So in this case, they might clarify, for instance, that the law triggers free speech and that it should be reviewed under strict scrutiny. So I think that as survivors, the most hopeful way out of the most hopeful outcome is that they do that, is that they send it back to the state court, and they tell the state court that they need to review this under strict scrutiny, and then there will be a subsequent opportunity for a evidentiary hearing. So a hearing where both parties are able to provide evidence, because there was some dispute in oral arguments about whether the state of Colorado was given the opportunity in the lower court to provide all the evidence it could. So I think that that's the most likely, the most positive outcome that survivors could expect. And at that point, there would be more of a chance for the state of Colorado to bring in more evidence to prove that talk-based conversion therapy is harmful. You might recall in oral arguments that both Mr. Campbell, who was the lawyer for Chiles, or this other individual who was a lawyer for the federal government who took the same position as Chiles, both kind of like passionately said that doing that, so remanding for review under strict scrutiny at the lower court, would, quote, irreparably harm not only Miss Chiles, but all of the children of Colorado, because they're all looking for her support, allegedly. So like that is, so whether that argument of like irreparable harm is like a very like litigious term that they're trying to use to try and avoid, because what would happen is it would go back to the lower court, there would be more evidentiary hearings, and then it would presumably work its way back up to the Supreme Court over a few years. And then the Supreme Court would have a final say on the evidence. So like, if let's say they go to the lower court sides with the state of Colorado, just like it did, and then the appeals court sides with the state of Colorado, then the Supreme Court can reverse all that and say, oh no, there wasn't enough evidence to uphold the law under strict scrutiny. I'm not super optimistic about the case with respect to that. And Again, you have to understand these cases in terms of like political movements. Like they take them for a reason, and it's not because they genuinely care about the like legal questions. It's because they want to accomplish a legal outcome. And that's why we really need to like us like when you're looking at this like from as a scholar, really want to look at this as political actors that are acting within a political system and not like these like independent bias-free jurists that, you know, are just looking out for the greater good. And the only other thing I will say is that this case had a lot of what are called amici briefs. Um, and I want to just kind of like shout out the fact that an amici brief was written for Conversion Therapy Survivors Network, which included a lot of testimony about the harms of talk-based conversion therapy. And so again, we take this like angle of looking at this from a way, from a with a lens that they're trying to accomplish a political thing. Although I salute like all of the organizations like Trevor Project, like us, that submitted Amici briefs. Amici just means friend of the court, by the way. From my perspective, evaluating this, and even if you look at like the Dobbs case that overruled Roe v. Wade, like it doesn't matter how much evidence you submit to this court. They are essentially de facto unelected legislators. And if you've ever worked with a legislator trying to pass a law, you know that like sometimes they just want to do what they want to do, and no amount of evidence will sway them in another direction. And so that's kind of comparable here, but it's still worth noting that many organizations, including ours, submitted, you know, testimony to the court that reflects the harms, the like very obvious harms of conversion therapy. On that note, I will stop talking, and well, I mean, I will partially stop talking, and I'm happy to take any questions.
I am confused about the whole speech adjacent conduct doctrine,
Okay.
mostly because of my training as a therapist. We talked a lot about how in medicine you have different tools and measurements, things that you give out. But we had psychometrics, we had questions that we would ask to get our tools, and that in therapy, or at least talk therapy, things we do specifically, certain types of questions, certain ways of asking a question were our clinical tools, and we were called
Yeah.
clinicians, and we were regulated within the tools that we use. So I guess I'm a little confused why they seem to be honed in on, speech adjacent because of giving out a medication when the tools of therapy is speech. So I guess I'm wondering, did you have any insight on why they seem to go there? Because it almost seems like if they make that type of ruling that like, oh yeah, all speech within therapy is free speech, it seems like they're saying therapists can literally say anything and everything and all of our theories are bupkis.
Yeah. So again, this was the best argument that they can come up with. So the lawyers and the legal team working for Chiles, the best argument they can come up with was that talk-based therapy is speech. Speech is protected as a protected class, and therefore it shouldn't be regulated. Now, obviously, I think any sane person would or should be able to classify, talk-based therapy as conduct, because there is conduct going on, like in terms of like you're not just sharing your opinions. Like this is not a kiki at the bar with your friends. Like this is a kind of like state regulated um form of treatment, right? From my perspective, like this argument about talk therapy being speech and there not being any conduct is rooted in the fact that this is the best argument that they could come up with to curtail this law. I will say that like just being impartial, even though I'm a survivor, like being impartial, I do think this California law, this Colorado law is particularly weak because it carves out space for life coaches, because why not? And ministers to engage in conversion therapy, whereas state regulated practitioners can't. And so it's a bit difficult when you're in front of the Supreme Court to argue that conversion therapy is harmful when you have passed a law that has a carve out for life coaches. Like ministers, okay, I understand that. Like that makes sense because even if it's harmful, you run into like freedom of religion issues, right? And so, although, you know, church-based or religion-based counseling, where counselors are not trained and where counselors are basically saying like, you know, whatever, and don't have any regulation, any supervision, don't have any like professional development responsibilities, that is harmful. But I can understand why a state would exempt that, because then you run into freedom of religion issues. However, and like I told Sam this week when we texted about this, you know, having a carve out for life coaches specifically is not really giving conversion therapy as harmful. It's like that's a bit unfortunate. And like I say that not to be mean, but I say that as someone that was very involved in passing a national ban for conversion therapy here in Canada in 2021. And there being, I think, 4 iterations of a potential bill that we had, and each iteration getting more strict. I think like it's a bit laughable to have a carve out for life coaches. But again, like going back to this speech adjacent conduct, like this is basically what they're leaning on. And this is why I think there is a chance that the case gets reviewed by the lower court on strict scrutiny, because if they throw it out entirely, it's very rare for the Supreme Court to like make a strict scrutiny assessment. Like they might say this falls under strict scrutiny, but they won't say whether the burden of strict scrutiny is satisfied. They will generally leave that to a lower court and then review on appeal, because the Supreme Court is not an evidentiary court. So they're not used to like, you know, you don't have a trial in front of the Supreme Court. Like they're not that kind of court. So it's possible that it gets remanded, and then it's anyone's guess, you know, what happens. But for them to rule that it's only speech, that talk-based therapy is only speech, it would be a bit crazy, because then I think you come into all of these issues where, okay, then if talk-based therapy is only speech and it's free speech, then what about all of the other regulations that regulate therapy? Then do other regulations, can you now discriminate against someone? You know, if you have a person of color, if you're a white therapist and you have a person of color, are you allowed to like treat them poorly because they're not white? Like it creates all of these other kind of issues that won't necessarily, doesn't mean that like, you know, that if they were to rule that talk-based therapy is pure speech, it doesn't mean that the next day therapists are going to start like discriminating against their clients, but it may result in subsequent cases where that becomes where licensing boards and licensing board regulations are put further to question, because this is a really radical like argument that anything a therapist says, as long as they're not prescribing medication or like hooking electroshock paddles to you, is speech, just like if you go to the bar and that decide to say that like all queer people are, you know, whatever derogatory thing you want to say. I think there was a question.
We do have a question in the chat. It says, is there a stronger argument to combat this freedom of speech violation angle?
I think based on what's already happened, the best outcome is a remand to the district court for an evidentiary hearing where the state would have to prove a couple of things. I'll just go back to the standards of review that I mentioned in the beginning, because I know it's a lot of information and I didn't make any slides or anything for this. But so again, strict scrutiny, the government bears the burden, and it's a very hard burden to meet. The law must be as restrictive as possible, while still being able to achieve its goal. And the law is presumed unconstitutional unless it's proven otherwise. And it has to be narrowly tailored. Sorry, I missed the first one. It has to be narrowly tailored to achieve a compelling government interest. So you have to, the state of Colorado would have to prove that the law is narrowly tailored and that banning conversion therapy is a compelling government interest. And in doing so, they would have to show through studies that it's harmful, or testimony. Like I presume you can also do testimony, but generally, ever since Brown v. Board of Education, so Brown v. Board of Education in the 1950s, which was a case that led to overturning the Plessy v. Ferguson decision that said that separate but equal was equal. That was the first case in which the Supreme Court accepted a science-based evidence. And there was a whole like study in that case, I'll just briefly historicize it, which is that there was a study that showed that white children, female children, and black female children were attracted to white dolls instead of black dolls, and that kind of showed that that was, for the Supreme Court, compelling scientific evidence that if you separate black girls and give them black dolls and white girls and give them white dolls, you still have a society which is gravitating towards whiteness. And that's when they overturned this segregation decision. And since then, the Supreme Court has heavily relied on like scientific data or whatever data is presented to them as science. And so the best outcome is, for me, because there's like the best outcome would be like the Supreme Court upholds the law and says that talk-based therapy is not free speech, it's treatment that is subjected to state regulation. That's not going to happen. I'm sorry. Like, it's just not going to happen. Like, to be honest, I don't even know that they have the liberal justices on board for that. But what could happen is it gets remanded to the district court. And at the district court, which they would be given evidence. Because again, there's a big difference between standing up in front of the Supreme Court and claiming that the studies say X and showing through evidence the district court what the studies say. Because the Supreme Court is not equipped to like navigate, are you cherry picking studies? Is what you're saying bullshit? They're not equipped to that. They need a lower court to make an evidentiary determination. And on the basis of that evidentiary determination, they will come up with a decision, and then the Supreme Court could review that decision. But the Supreme Court is not in itself equipped. Like, the people on that court are not educated in anything other than the law. So they don't really like have a, and they don't do this on a regular basis. A district court does this on a regular basis. I'll just address Chris's subsequent point, which is whether the Colorado Solicitor General falls short. Like, it's unfortunate, but when a law is passed and then it's challenged on the basis of constitutionality, the person who comes to the defense of that law is the Solicitor General of the state. I don't know her about her. What I can say is that listening to her in front of the Supreme Court, she seemed not very well prepared to face combative questions from politically radical right-leaning justices like Samuel Alito and Clarence Thomas. And she didn't seem particularly passionate about what she was defending. So let's say, for instance, we would have, or the law would have been overturned at the appellate level. Then an appeal could have been brought by a third party like the ACLU or the Human Rights Campaign. Just like the Skrmetti case, I believe it was the ACLU that brought the case. And so the person who argued the case is a trans man lawyer who works for the ACLU. And so there is more kind of passion and personal like weight in the case. So I don't want to like, I don't know her, so I don't know her relation to like conversion therapy, if she knows about it, if she cares about it, I don't know. All I can say is that I listen to almost every Supreme Court argument every term. So like, I listen to a lot of these solicitor generals give arguments. She did not do well. Like, she seemed ill prepared and was not able to answer. Again, like, the questions are meant to trip her up because this is a political arena. This is not a independent judicial arena anymore. But nonetheless, I would say that she didn't come prepared, and particularly with respect to making a distinction of why regulate therapists when you're not regulating life coaches. Like, she didn't really have an answer for much of that. And like, although she was hounded by Alito in a way that made me want to punch him in the face, nonetheless, I don't think that she was really able to stand her ground and demonstrate the harm, because there was this whole aspect of the argument where she was asked about the studies, and she just said that like the Campbell, the lawyer for Chiles, said that like the state argued that the state was not able to provide any evidence that conversion therapy is harmful. I don't really believe that, but she was sitting there in the courtroom. She heard those arguments, and she could have interwoven that into answering some questions, and she didn't. All she said was that there was never a hearing at the lower court level that allowed them to. I'm not sure if that's true or not. I haven't dug through all of the documents to find the answer to that, but I just find that the responses were not really well done. And there was this other, before I get to Danielle's question or comment, I will just say that there was this other line of argument that I haven't mentioned yet, which was, what about if we were in the 1970s when homosexuality was listed as a mental disorder in the DSM? Would it have been okay for a state government to ban a therapist from counseling their client into accepting their sexuality? Again, we're thinking 1970s, where homosexuality is considered a mental disorder. And so this was like a constant trope by the conservative justices, like bringing this up. So she tried to say, so she answered yes, they in that case. So Stevenson, the Solicitor General, Shannon Stevenson, said that yes, in that case, it would have been acceptable, but she tried to bring it back to, but it would still have only been subjected to rational basis review instead of strict scrutiny. And I think that trying to continually say that, it should be reviewed under rational basis review, which is the lowest in the hierarchy of standards of review, is implying that there is a weakness in the evidence, because you should be able to say that you can prove it under both. So if you can say that, I'm not sure if that's because they don't have the evidence, they don't believe they have the evidence, or they're just trying to get out easy. But it seemed to me that there was like a bit of a fear on her behalf that making any kind of argument that invited strict scrutiny was not acceptable for her legal team, however they decided to come to that conclusion. She was also asked by Amy Coney Barrett about evidence, and so she brings up a couple of studies. There is this kind of like back and forth, because so normally the petitioner's lawyer has an opportunity to come back and rebut something that the appellant's lawyer says. So there was like a 5-7 minute like rebuttal at the end. And when she brings up the study, she brings up the lawyer for the petitioner, Campbell, basically says that like all of these studies are flawed because either there's like sampling errors, they don't distinguish between different types of conversion therapy, aversive therapy, reparative therapy, talk therapy, or they don't distinguish between youth and adults. Studies on conversion therapy are new-ish because you need funding to do studies, you need funding. And so it's possible that there are some conflations, especially because conversion therapy is not a real therapy. So like if you were trying to study the harms of CBT, it would be easy to study that because everyone knows what CBT is because it's like medically defined. The problem with studying conversion therapy is that no one knows that it is because it's not an actual thing. And so it's very, just as an academic without any kind of like direct knowledge on the literature, it's possible that have been struggles by different scholars trying to kind of like properly define what it is. And so it's possible that the lawyers for the petitioner exploited that by trying to argue that like not all of all the literature should be thrown out because nobody knows what the F they're studying, because none of it is defined. So that's why I lean on the best case scenario being that, sorry, I hope I'm not frozen. The best case scenario being remand, because then there will be a kind of more exhaustive opportunity for the state to kind of prove harm. I'll just move on to the next question. This might have been survey, can really anything. Yeah, so I'm sorry, I didn't see your comment, Danielle, but I kind of just addressed this, which is this kind of like flip side argument that was brought up over and over again. And I think it's a trip up argument, but it's fine to say so if homosexuality was still a mental disorder in the DSM, that it would be lawful under US law for a government to restrict the ability of a therapist to counsel their client to accept their sexuality if we are working the presumption that it is a disorder. I'll just go to the next question. If there's a remand to district court, is there anything we can do to assist? Not sure. Probably, I would just say write to the Solicitor General's office and ask if you can provide firsthand testimony. I think like when this case was announced, I had a lot of people reach out to me about helping. And the thing is, if what you have to be careful of is this case specifically concerns talk-based therapy by a licensed state practitioner. So if your CT experience is you went to a thought-based therapist who did nothing else but talk to you and counseled you to whatever, fast, act more manly, whatever, that cause more harm, shame, guilt, etc., then I would write to the Solicitor General of Colorado's office and ask them that how you can go about providing firsthand testimony of that. I will just say in the current political climate, if you do that, your name will be part of the record. So also consider that in your kind of process of deciding whether you would want to do that. But like I had a lot of people, like for example, my CT experience is based on is from church-based counseling, where I was in counseling sessions with a pastor. So that has nothing to do with this case. I was, I think maybe one time in a session or two when I was in Bible college with a like therapist. I don't remember their names. I don't know what their affiliation was. I'm sure they were state regulated, but I have no idea. But that's not where the bulk of my experience comes from. So like there's nothing I can do to help this case in terms of like my personal experience. But if your personal experience is in talk-based therapy, so like a counselor, a psychotherapist, or a psychologist, are there any other classifications, Sam, in the US? Counselor, psychotherapist, psychologist?
On the spot, I can't think of any.
Okay, so I think that's generally like maybe social worker. Yeah, master social work license. Okay, yeah. So if your experience is with any of these, like state regulated individuals, then I would say reach out to the Solicitor General's office. But just to give you an idea of, for people that don't know how this works, I'll just briefly explain to you how decisions are done in the Supreme Court. So on Friday, the Supreme Court had a conference day, which means that all the justices meet behind closed doors with no one taking any notes or recording what is happening, just the elites meeting behind closed doors. And by a show of hands, they would have voted whether they're going to rule for Chiles or for Salazar. And then let's say, for example, there's a majority of people the majority of the justices that say they're going to rule for Chiles, then the Chief Justice will assign the opinion writing for the majority to the most senior justice in the majority, which is either Roberts, the Chief Justice, if he's in the majority, or Samuel Alito, or Clarence Thomas. So if that makes you want to vomit, join the club. So they can also pass and say, I don't want to write this one, and it goes down the line, basically, to whomever wants it. I regret to inform you that I am very skeptical that Samuel Alito will ever pass on writing an opinion like this, because in oral arguments, specifically when they were questioning Shannon Stevenson, the Solicitor General, he was talking about viewpoint-based discrimination. And if anybody's familiar with lovely Samuel Alito, one of the senior Republican justices on the Supreme Court, you will know that he hates viewpoint-based discrimination. Even if John Roberts, if John Roberts writes the opinion of this case, whatever, like it's still gonna be bad. If Alito writes it, I think it's very likely that it doesn't get remanded, because he'll probably say something like, he'll probably lean on like the irreparable harm. But basically sorry, I got a bit distracted, ADHD. The point of me saying all this was that, so as of now, like if Alito has whoever has the opinion, they're going to write it. It's the same thing in the dissent. So whoever's in dissent, the senior justice on that side writes it. Sometimes, depending on the case, multiple justices in the dissent will write their own separate dissents. Sometimes, it's very rare, but like in the Dobbs case, nobody, like they all wrote it together, but nobody signed it. It was just like from everyone with no specific author, because that's supposed to be like even like to carry even a stronger message. And so from now till June, they will be like, normally what happens, this is a lot of the research work that I do with respect to the Supreme Court, is that someone will write the first draft, it gets circulated to the other justices, and there's like marginal notes added. And then there's like this whole kind of political jockeying process that happens behind the scenes. And then the decision will come out at some point in June. If you're interested in that, like you can follow the media. They might be good enough to tell you like when a decision is going to come out. The other thing to do is you can go to the Supreme Court's website, which is supremecourt.gov, and you will see on the left-hand side of your screen, there is a box that says today at the court, and there is a calendar right next to it. And so you will see on the calendar, in the spring, there will be, I think it's usually yellow, what's called opinion issuance days. And so like often it'll be like Monday night, there's nothing, or so Monday there's nothing, and Monday night all of a sudden this like yellow box appears for Tuesday morning. Opinions get released at 10 a.m. at intervals of 10 minutes. And so you can just, if you're on the Supreme Court website, you would just click on opinions, then opinions of the court. And if you go there now, you'll just see it says term year 2025, and there's nothing there. And so the morning gets released, at 10 a.m. You can look. They won't tell you in advance, so you just know when it's released. So you might check every day, and it might just be like 3 weeks after when everything else is decided it's there. And that's when we'll know. Are there any other questions? I did want to make a podcast recommendation before we go there.
I have a question.
Yeah.
So the scenario you just described, I assume, is the potential worst case scenario. And I assume that means all of our bands are at risk if that happens. Is that correct?
So worst case scenario is that the like in my view, worst case scenario is the opinion goes to Justice Alito, and the decision is that talk-based therapy is speech, therefore protected under the First Amendment, and strict scrutiny applies. But in this case, because it would cause irreparable damage to Chiles, we're not even going to remand. We're just going to say that it's unconstitutional. That's worst case scenario. Second worst case scenario is that it gets remanded and then eventually goes up. Like I'm not going to like sugarcoat it. I'm going to be honest. Second worst case scenario gets remanded. There's an evidentiary hearing. Very possible that the circuit court, the district court rules in the favor of Colorado. The circuit court rules in the favor of Colorado. It goes back up to Supreme Court. The Supreme Court says not compelling enough evidence. It doesn't meet the standards of strict scrutiny. Very likely that is going to happen. So it's just delaying the quote unquote inevitable. In terms of overturning other state laws, I am not 100% sure because I'm not familiar with each state law. If a state law, so this case turns on whether talk-based therapy is free speech and only free speech, not speech adjacent to conduct. So if they rule that, and there are other states that have bans on conversion therapy that is only talk-based therapy, then it's possible that what would happen is that, let's say, for example, I'm a therapist in Minnesota. I would assume Minnesota is probably a state that has a ban. Let's say I'm a therapist in Minnesota, and I think I should be able to tell my clients that are minors that they can change their sexual orientation by doing whatever. And the Supreme Court does like worst case scenario. I would then have to sue the state, citing the precedent, and then it would be the district court that would have to apply the precedent. So it's not necessarily de facto like remove. Like for example, in 2003, when the Supreme Court ruled that laws against sodomy, so like same-sex relations, were unconstitutional, I think last I did a research project on this, it was 18 states that still have sodomy statutes in place. Those are unenforceable, so nobody was arrested for sodomy after the Supreme Court ruled this, and then had to tell the district court this case should be thrown out because the Supreme Court ruled X. So some cases in the Supreme Court have an automatic chilling effect of stopping like prosecution on the basis of sodomy, for example. But other ones might require someone to file a lawsuit. It's also like what I will say about bans on conversion therapy is that I have yet to hear about a prosecution in Canada or the United States. Like Canada has a ban. I don't think we've prosecuted anyone. So like I'd say there is an issue with like defining conversion therapy, prosecuting it. And I think that a large positive of conversion therapy bans is just the chilling effect of it being in place, that you might get prosecuted, kind of prohibits you from doing that. On top of the fact that like if you are accredited by like I don't know, like the Psychological Association of Massachusetts, like generally those associations like preclude you from engaging in like therapeutic methods that are not rooted in science. Generally, it's a chilling effect. So I think that what might happen if they were to rule worst case scenario is that therapists in other states will then start engaging or flirting with the line a little bit more of conversion therapy and then engaging more. I don't want to, I'll just say that it's a bit tricky because of the kind of merging of sexual orientation and gender identity together in conversion therapy, because homosexuality is not a disorder. It hasn't been for a long time, but gender dysphoria is a thing. And so there is potential like issues with banning therapists from talking about gender dysphoria when that could be something that's experienced by someone legitimately, not in the way that the right misuses that. But so there are some issues where I think in this kind of case, the sexual orientation aspect might just be put on the back burner because of the kind of political witch hunt against transgender individuals on the right. I will say, okay, I want to recommend the podcast if people don't already listen to it. Ironically, the name of the podcast is called Strict Scrutiny. It is a weekly podcast. It's been around for like 4 years. It's hosted by three law professors: Leah Littman from, I believe, Michigan State, Melissa Murray, who is at NYU. She's also a contributor and often is a replacement anchor on MSNBC, and Kate Shaw, who is the wife of Chris Hayes, who does the 8 o'clock hour on MSNBC. They are phenomenal. People might be familiar with like Pod Save America, which is part of the Crooked Media Network. Strict Scrutiny was originally independent. They were bought out by them a few years ago. And so it's part of this, like, Pod Save the World, Pod Save America, all of them. So it's part of that. Their episodes come out on Monday mornings. I am friendly with one of the hosts, so I emailed her and she said that they're going to cover this case in their episode tomorrow. I highly recommend listening to it because you'll have even better of a legal analysis than I can give. But the episode before, so the episode that came out last Monday, is like a kind of peek into this term of the highlighted cases. So they do talk about it. I think about 20 minutes in, they talk about the Chiles case for about 5 minutes and basically chalk it down to the Supreme Court will take away the rights of everyone except the rights of people that are in their like sphere of interest, like rich people, donors, billionaires, etc. It's a really phenomenal podcast. Like highly recommend it just regularly because they're really, really good at like interweaving a kind of like discourse about pop culture into like discussions of complex legal issues that are understandable. So like typically what they will do when it's June and opinions start coming out, they will release like what they call like emergency episodes where they go into detail on big decisions. Sorry, I think I might be freezing up a little bit. Yeah, so I like highly recommend it. There's other podcasts. There's other legal podcasts. There's one that's done by the Daily Wire. So if you're really interested in hearing like kind of like a slew of different, one that's called Amicus, but it's produced by Slate. Person who hosted Dahlia Litwick is phenomenal, so that's a really good one as well. And there's one by Bloomberg called Cases and Controversies that might be good as well. Highly recommend those, but Strict Scrutiny is obviously like for me like the best. I'll also mention that we have the Conversion Therapy Survivors Network, or maybe Sam can plug the meeting that we have at 7:30.
Yeah, I was just going to say that since it doesn't look like we have any questions and you've talked at length, giving us information from your experience, I just want to encourage everyone to know that Conversion Therapy Survivor Network is here to support survivors. And in our community, there's definitely a lot of conversations about the effectiveness of these bans. As you noted, it wouldn't have protected a large majority of us. And those bans still matter because it protects kids, right? So I think that we should never forget that the fight will move on. Conversion Therapy Survivor Network will be here to try and help people heal. We have a weekly support group. You can donate at conversionsurvivor.org. And if you're a survivor and you want something to do, there are two avenues that I think can be really helpful. One, know that on January the 7th, there is going to be an International Day to End Conversion Therapy. We are working with other organizations that survivors are supported by in other countries, and we are helping to create this January 7th day of International Day to End Conversion Therapy. So keep an eye open for that. We are working on making celebrations for that. Share your stories online. And if you want to share your story on a podcast, we are now making recordings. You can email us at podcast@conversionsurvivor.org. All of these resources from Jonathan and from me about the podcast, about January 7th, we're going to be putting it in our show notes on our channel on YouTube. So if you just go to YouTube and go to Conversion Therapy Survivor Network, you'll be able to see this recording, and you'll hear that, see all the resources there. So do not despair. We are here as a community, and we will keep doing what we can to support survivors. So that's the plug for the org.
Thank you so much, Jonathan. I know that's a lot to go over and a lot to wade through, so I'm sure there'll be plenty
Thank you
more
for having
questions.
me.
All right, well, thank you, everyone. I did drop in. If you wanted to attend our Survivor Sunday, it does start in about 15 minutes. We'll see you next time, so thank you very much, everyone. Have a good night.